I know what you're thinking. Didn't I just do this a year ago? And the answer is yes. Yes, I did. But today we're here to talk about the July 2023 updates to the North Carolina Standard Offer to Purchase and Contract. Let's start from the top. So I actually have the commentary from the North Carolina Association of Realtors and then the marked up contract. So I'll be referring to those two documents. So first up, last year you'll remember that the contract added a checkbox as to whether the property would include a manufactured home. So that checkbox is still there, but there are new checkboxes to say whether or not the property will include an off-site or separate septic lot, because that is something that is common here. A boat slip, another common thing in the lake, a garage, parking space, or storage unit. So if there's that septic lot, boat slip, etc., encouraging the use of the additional provisions addendum to further clarify the rights and obligations of the parties. Now, under 1G, this is the definition of the effective date, which is the last date of the parties to sign the final contract. So not necessarily like the initial offer. If there's a counter offer, then you got to countersign, so on and so forth. But there's a new sentence here, and it says, the parties further acknowledge that the effectiveness of this contract is not contingent on buyer's payment of any earnest money deposit or due diligence fee. It's really important here to know that the contract is binding as of the effective date, not upon the delivery of the funds. All right, moving on to section 2B. This is a hot topic, exercise equipment. My husband, who is behind the camera right now, has what I would say is an extensive at-home gym with lots of equipment. So there has been a bullet point added here that says exercise equipment or devices that are attached will be transferred to the buyer at closing. So this is not your exercise bike that you move around. This is not your Peloton. This is not your row machine. This is, pull-up bars or some other sort of equipment that is actually attached to the wall. And this was put in here specifically, the commentary from the North Carolina Association of Realtors is that listing these items specifically will help agents have earlier discussions with their clients and make clear that any attached equipment will be transferred to the buyer at closing. And if for some reason, the seller does not want that item to transfer, that needs to be made abundantly clear in the contract. Other things here, buyer's due diligence process. In paragraph 4, there has been language added to encourage buyer to undertake investigation with governmental compliance. For example, I lived in a house that was built in the late 90s and it was built violating the setbacks. That was something that we knew going into it. When we sold, we disclosed that. That was made very clear, in the listing. It was made part of the contract that it was understood. So that's an example of governmental compliance, disclose up front. And then say the seller for some reason doesn't know, didn't obtain a survey, whatever it may be when they bought. If the violation is discovered after the effective date and prior to closing, the seller may cure the violation. And then unless otherwise agreed, if the seller doesn't cure prior to closing, there's two options. Buyer can accept the violation and proceed to closing, or terminate and get earnest money and due diligence back. This one is a big one, and this is in section 8G, and this is good title, legal access. And this is the paragraph that talks about the seller's obligation to deliver good title to the property, so both marketable and insurable. There's been a very specific change here that makes a very big difference. Whereas before, it said seller shall convey fee simple, marketable, and insurable title that was free of, without exception for mechanics liens and free of any other liens, encumbrances, or defects. Now it says free of other encumbrances or defects, this is the big part, that would materially affect the value of the property. Now listen to the commentary of why this was added. So language has been clarified to state that the seller only needs to convey the property free of any material encumbrances. The existing language has no such qualifier. This is the prime example of where I see this. So this sometimes results in a buyer trying to use an immaterial encumbrance, such as a 6-inch fence encroachment on a small corner of the property, to back out of the contract after due diligence, even though the seller can deliver marketable and insurable title. A 6-inch fence encroachment is almost never material. You never say never, because there might be instances where it is, but we do often see parties try to back out of the contract because there is an encroachment. It's not going to affect the value of the property, but the encroachment does in fact exist, and that is a title defect. Defect doesn't mean, you know, the property is worthless, but it is a cloud on title. So the language adding a material defect or material encumbrance is going to be huge. It's going to help a lot in resolving disputes over minor fence encroachments, but I think it may also create a few more disputes as to the parties disagreeing over what in fact is material. And then next, Section 8I. This used to be Section H, but as we talked about earlier, there is a new Section H. Deed, taxes, and fees. This was the part of the contract where you can say the deed is to be made to and list someone that either is the buyer listed on the contract or someone other than buyer. And this is where it gets tricky. If this was filled out incorrectly or needs to be changed, then the lender, or even in some cases the attorney's office, may need the contract changed in order to make the deed out to whomever the buyer wants the deed made to. So to prevent unnecessary back and forth to try to get the contract amended, rather than saying the deed is to be made to and just have all the blank lines, it now says the deed is to be made to buyer, a corporation, LLC, or other business entity of which buyer is the sole owner or shareholder, a trust for which buyer is the beneficiary, any relative of buyer, and or other, which is where you would insert a name. So you don't have to insert a name if you're intending to convey the deed to an LLC that you own or have formed for the purpose of buying the property. If you are going to want the property deeded to a trust that you're the beneficiary of, if you want to deed the property to a relative of yours. The only reason you would have to put in a name is if you are trying to deed the property, or you want the deed to be made out to someone other than those new 1, 2, 3, and 4. Now, paragraph 19, this one's interesting, and I think this is to prevent maybe upset parties. And the commentary says usually the buyer recording this contract to create a cloud on title. So then it says here, this agreement or any memorandum thereof shall not be recorded without the express written consent of buyer or seller. So if the parties have moved on, or the transaction has fallen apart, and a buyer is upset and says, I want to make it difficult for the seller to try to sell it to anyone else, and they try to record this contract, you can't do that. You can't do that anymore without express consent of buyer and seller, typically from preparing a memorandum of contract signed by both parties. So surprisingly, even though this is a long one and has a lot of information, this is not even as much, not even as many changes as last year. So less changes than last year, but still some important ones. If you are a North Carolina real estate agent, make sure beginning next month you start using the new version of the contract, 7/20/23. I had to make sure that it has all of these new provisions in there. So hopefully this explains some of the new things and the reason why. As always, we love to put out videos just like this one to help you understand more about North Carolina real estate law. I'm Tiffany Weber. I'll catch you in the next video.